Now that we have taken an introduction to the subject of wills and the administration of estates, what we're going to do in this lesson is begin by just taking an introduction to the idea of the will, the purpose of wills, and provide us with some foundational knowledge which we'll then take forward into looking at the specification in more detail. So we're going to be looking at the first part of our conversation regarding the idea of wills and the administration of estates. And this really involves introducing you to the first topic within the specification, the validity of wills and codicils. We'll get to codicils later on, but we will focus firstly on the idea of the will. And generally speaking, when we think about wills, we have to think about the first very simple and very basic fact. There is a fact of life that throughout a person's life, there is the accumulation of property. A person lives their life, they buy things, they earn money, they purchase items, they purchase land. This therefore means that there is an accumulation of property that is in the form of money, maybe a bank account, maybe an investment, maybe a trust fund. There is the accumulation of property in terms of, let's say, real property. So things like land, for example, they may have had a mortgage earlier on in life and then have essentially developed has ownership of a property. Maybe they have a house, maybe they have a farm, maybe they have multiple houses, maybe they have a property portfolio. Or even the idea of personal property, your grandparents' prized china, for example, very, very rare pottery and things like that, a television, a laptop, a phone. This is a natural fact of life. And ultimately, these are all things that have a certain sense of permanence that life does not. A person will live their life and then they will eventually die. But when they die, their property doesn't die with them. And this is really the entire conversation that we're having with regards to wills and the administration of estates. The question for us then in this series of lessons is what happens when this person dies, specifically what happens to this person's property. And so this brings us to the conversation about what is a will. Ultimately, a will is not actually something that has been historically very easy to define. Historically, there is not the strong definition of a will that you might find in the case of other concepts, for example. We can sometimes find definitions in the case law, but it should be noted that neither the legislature, Parliament, nor the judiciary have been too keen to provide us with a very strong legalistic definition of a will. One example that we see here that represents a bit of extension material for you is the case of Limange and Goodburn from 1865. This tells us that, quote, "The will of a man is the aggregate of his testamentary intentions, so far as they are manifested in writing, duly executed according to the statute, and as a will, if contained in one document, may be of several sheets, so it may consist of several independent papers, each so executed." Not the best definition of a will, not the most clear-cut idea of a will or a clear-cut idea of a definition, but it brings us at least into the conversation about what wills are meant for. They are essentially meant for trying to determine the aggregate of an individual's testamentary intentions. And so fundamentally then, the questions that we might ask as a solicitor when thinking about this area of law, when thinking about the idea of wills and the administration of estates, is firstly, is there a will when a person dies? So if you're a solicitor and if you are dealing with an individual's property after death, the first question you might ask is, firstly, is there a will? If the answer to that question is yes, then you might ask a follow-up question. This follow-up question is going to be the topic of the next few lessons, because this follow-up question is whether or not that will is in fact valid. And there are certain requirements for the validity of a will, including intention, testamentary capacity, and a certain sense of formalities, as we see in Section 9 of the Wills Act. The next question might be, is there any property that has passed or that should be passed independently of the will? That is going to be the topic of the next lesson, thinking about the types of properties that will pass outside of the hands of the testator, regardless of whether or not there is a will, or regardless of what the will says. This includes things like pension funds. This includes things like the events that take place upon the death of an individual, if they are, for example, the beneficiary in a trust and they have some kind of equitable interest. That will be the topic of the next lesson. The next question is there any property left that neither passes in the will instrument or has passed outside of the will instrument? And so what do we do with that property? And then I would also want to add, if there's a final question, is if there is not a will, then we have to think about then what are the rules of intestacy that we have to think about in regards to that question as well. All of this will be topics that we will explore in more detail as we go through future lessons.